Welcome to week 11 of Research Ethics. In week 11, you will have required activities that consist of your weekly readings, the discussion questions, and the week 11 individual assignments. Through the successful completion of the required activities, you will be able to fulfill the course learning objectives, and those are knowing about property rights, evaluating types of intellectual property, and understanding violations of intellectual property law. And when you fulfill these learning objectives, your readings are going to be about intellectual property. And intellectual property are considered patents, copyrights, trademarks, and trade secrets. And the legal foundation for US intellectual property rights was laid by the founders in 1787 in the first article of the US Constitution. And basically, it's to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. Patents are an intellectual property right granted by the government of a nation to an inventor that gives him or her the exclusive right to the invention for up to 20 years in exchange for disclosing the details of the new technology to society for its ultimate benefit. Copyrights is an intellectual property right granted by a government to the author of an original, literary, dramatic, musical, artistic, or other eligible creative work. Trademarks is an intellectual property right granted by a government to individual, business, or legal entity that creates and uses a distinctive word, name, symbol, or device to distinguish its products or services from those from any other entity in the marketplace. And trade secrets is a law that requires that the intellectual property to be protected, not publicly disclosed. Patents, which we talked about, which is an intellectual property right granted by the government of a nation to an inventor, it dates back to Greece 500 years before Christ, Europe in the 1700s, and it also reinforced the wealth of the high society. And patent-like incentives first appeared in ancient Greece and continued to spread throughout Europe. Early patent systems reinforced the wealth of those in high society. There were British also patent application fees were more than 11 times per capita income of the average citizen, and it was a restricted innovation to a small sector of the population. And the rationale for issuing a patent is that it was really to stimulate the inventive genius and entrepreneurial energy of the common man. And of course, the goals of today's US patent system, again, is to stimulate invention and protect property rights to help ensure creation and productivity, and also to share knowledge. It promotes progress and the general welfare by disclosing inventions. And how did the US create a patent system for everyone? Well, it had 6 unique features. It was a simple application procedure, it had low fees, no working requirements, disclosure of new technology, it had an examination system, and it was a new technology in the marketplace. And what exactly can you patent? Well, according to the Patent Act, you can, you can patent a machine, something you manufacture, a process, or a composition of matter that can be patented if it demonstrates the following 3 characteristics of its novelty, non-obviousness, and of course it has a good utility, and the utility basically is that the invention must function as intended. And products and processes are 2 examples of things that you can patent. And those are like, something physical. If you manufacture a physical product, a composition of matter. Composition of matter can be like glue or a mixture of glue. Manufacture can be something like like a physical product, an automobile, or it could be a television set. Processes are defined as a means to an end, a means of doing something new or a new way of doing something old. Um, and of course, patent rights are enforced, and it's patent holders have the legal right to exclude others from making, using, selling, or importing the invention. Um, and of course, licensing is very important if the objective is to obtain royalty for the use of one's invention. And litigation usually happens when the objective is to stop a competitor from offering a product that infringes on one's patent. Um, And basically, should you take a claim to court regarding this? Well, when a patent is enforced through litigation, you must determine the who, what, where, when, and how of events. So you would have to determine like who infringed, create a claim chart detailing the product and service that was infringed, determine your location of the suit, file your claim as soon as you have proof, and select a judge or jury. There's going to be a trial and appeal board. Under the America Invents Act, third parties can challenge patents if evidence or warrants have their claims invalidated and so forth. There's alternatives to litigation, which are mediation and arbitration. And of course, there's more information that you're going to be reading about in the text that relates to intellectual property and the ways that you can protect yourself um, from other competitors trying to imitate you or copy your work, as well as you knowing the intellectual property rights so that you are careful in the work that you produce and you ensure that it is original. So remember, continue the readings in week 11, complete your discussion boards, your individual assignments, and that content will fulfill your learning objectives, which is knowing about property rights, the types of intellectual property, and violations of intellectual property law. Good luck. If you have any questions, feel free to reach out to me.